Criminal law is a body of law that pertains to crime and the regulation of social conduct and behavior. It involves the prosecution of individuals who have been accused of committing acts that are considered unacceptable by society. Essentially, criminal law seeks to maintain public order and safety, protect individuals, and use punishment as a deterrent to crime. The criminality or otherwise of an act should depend upon the degree of its antisociality. An act must be viewed with reference to the accepted rules of morality of the community in question. It is on this basis that crime is defined as an act or omission which amounts on the parts of the doer or omitter to a disregard of the fundamental values of a society, thereby threatening and/or affecting life, limb, reputation, and property of another or the citizens, or the safety, security, cohesion, and order, be this political, economic, or social, of the community at any given time, to the extent that it justifies society's effective interference through and by means of its appropriate legal machinery. This is an a priori definition. However, the failure of lawyers to agree on a particular satisfactory definition of crime has led to other multiplicity of definitions, which are institution-based. They are within the acceptable limit, and all have the coloration of the a posteriori and a priori approach to the definition of crime.
Juristic approach to the definition of crime. For the purpose of this lecture, the words crime and offense have the same meaning assigned to them because they mean one and the same thing. Okonkwo and Naish, in their book Criminal Law in Nigeria, define crime as those breaches of the law resulting in special accusatorial procedure controlled by the state and liable to sanction over and above compensation and costs. The above definition leads us to a distinction between the accusatorial procedure, in which the accused is deemed not guilty until he is found guilty, and inquisitorial procedure, wherein the person is neither charged nor accused, but an inquiry is made before commission for trial.
Judicial approach to the definition of crime. In the all-important case of R.V. Tyler, 2 QB 594, crime was defined as an act committed or omitted in violation of public law, either forbidding or commanding it. This is a definition that has taken root from the definition advanced by Blackstone in the book Commentaries on the Laws of England, Volume 4, at page 5. Another case which has defined crime is Conybeare v. London School Board, 1961, 1 QB 118, where Day J stated that a crime is an offence against the Crown for which an indictment will lie. It appears that this definition is narrow because it seems to have ignored minor offences that can be tried summarily and not by indictment.
The Criminal Code Act Cap. 77 Laws of the Federation of Nigeria. 1990, particularly in Section 2 thereof, has defined crime thus: an act or omission which renders the person doing the act or making the omission liable to punishment under this code or under any act or law is called an offence. From the above definition, it can be seen that if a particular act or omission has not been criminalized as a crime by the code or any other criminal statutes, such act or omission cannot be regarded as an offence in the eye of the law. Furthermore, Section 11 of the Criminal Code, which deals with the effect of changes in law, provides that a person shall not be punished for doing or omitting to do an act, unless the act or omission constituted an offence under the law in force when it occurred. The Penal Code Law of Northern Region has also legislated elaborately on this. See Section 3, Subsection 1 of the Penal Code Law. The Constitution of the Federal Republic of Nigeria, 1999, has provided for the definition of crime in its Section 36, Subsection 12, when it says that subject as otherwise provided by this Constitution, a person shall not be convicted of a criminal offence unless that offence is defined, and penalty therefore is prescribed in a written law which refers to an act of the National Assembly or a law of state. Any subsidiary legislation or instrument, by the above provisions of the Constitution, for any act or omission to constitute an offence, it must have been provided for in a written law, and punishment for such offence prescribed accordingly in a written law. Section 36. Subsection 8 of the 1999 Constitution states that no person shall be held to be guilty of a criminal offense on account of any act or omission that did not, at the time it took place, constitute such an offense, and no penalty shall be imposed for any criminal offense heavier than the penalty in force at the time the offense was committed. The above section speaks against retroactive application for an offense or omission. It emphasizes the fact that a person can only be punished based on an existing law and on the punishment which that law has expressly provided for.
We have seen crime to be an act of omission which the law has labeled as such. But immorality or sin is a different thing. It is an act which society or community abhors. It is an act of moral depravity. Thus, it can be said that an act may be immoral but not a crime. Though many illegal or criminal acts are immoral, not all immoral acts are criminal. For instance, in the criminal code which applies in the southern states of Nigeria, adultery is not a crime though it is an act of immorality. But conduct such as stealing may constitute both a crime and an immorality, and that is not to say that crime and immorality are the same thing. They are not so, and therefore cannot be. The dictum of Lord Atkin in Proprietary Articles Trade Association v. Attorney General for Canada, 1931 AC 310 at 324 said, "Morality and criminality are far from coextensive, nor is the sphere of criminality necessarily part of a more extensive field covered by morality, unless the moral code necessarily disapproves of all acts prohibited by the state, in which case the argument moves in a circle. Strictly speaking, what the immortal words of Lord Atkin mean is that crime and sin or immorality do not have the same scope and extent. This means that as they are coextensive, they are far from having the same scope, extent and direction. It is, however, important to note that when the criminal law reflects the society's sense of morality, the task of law enforcement is likely to be easier. This is because members of that society would feel a sense of obligation to obey the law.
This unit is very important in that attempts were made at defining crime. The different schools of thought tried to define crime from their own institutional and perspective viewpoints. Having read through this unit, you should be able to define crime and should be able to discuss the relationship between your definition and what operates in Nigeria. As you go further in your studies, these concepts shall become clearer to you.
Summary. The study of this unit highlights the following facts. The word crime is not different from the word offense. That is, if a particular law does not make a particular act or omission an offense, such act or omission cannot be regarded as an offense. While the juristic approach defines crime as an offense against the state, the judicial approach defines crime as an act in which an indictment or an information will lie. The statutory approach emphasizes the criminalization of an act or omission for such to be regarded as an offense. Crime and immorality belong not to the same, but to different regimes of behavior. Assignment 1. Using known approaches, critically examine the definition of crime. 2. If an accused person is punished for an act which did not constitute an offense at the time the offense was committed, what is the position of the law? 7.0 References and further reading. Introduction to Nigeria Criminal Law. Okonkwo and Naish, 1990. Criminal Law in Nigeria. Ibadan Spectrum Law Publishing. Karibi White, AG, 1993. History and Sources of Nigerian Criminal Law. Ibadan Spectrum Law Publishing. The Criminal Code Act, Law of the Federation of Nigeria Cap. 77. The Penal Code Law 1959 of Northern Region. The Constitution of the Federal Republic of Nigeria 1999. Unit 3, Elements of an Offense. This unit will introduce you to the elements of an offense. The elements of an offense are contained in that particular offense depending on how such offense is worded. In other words, it is through a thorough comprehension of the definition of an offense that one will discover the elements of that offense. This unit is fashioned as follows. Contents: Introduction to Nigeria Criminal Law. Introduction Objectives. 3.0 Main Content. 3.1 The Physical Element. 3.2 The Mental Element. 3.3 The Concurrence of the Physical Element and the Mental Element. 4.1 Conclusion, 5.0 Summary, 6.02 Remark Assignment, 7.0 References and further reading, 1.0 Introduction. In the accusatorial criminal system applicable in Nigeria, the prosecution must perforce prove all the elements of an offense for which an accused person is standing trial. Every offense has two elements, that is to say, the physical element and the mental element, except strict liability offenses which are complete upon the manifestation of the physical element only. The physical element is the act or omission done or omitted, while the mental element is the intent to commit or omit the crime. The English common law regarded the physical element to mean the actus reus, which is a Latin expression meaning guilty act, and the mental element, otherwise known as the mens rea, to mean the guilty mind. While the physical element is manifested in the act complained of, the mental element requires the proof of knowledge and foresight on the part of the accused. 2.0 Objectives. At the end of this unit, we should be able to explain what constitutes the physical elements of an offense and its various manifestations, identify the different states of mind which constitute the mental element of an offense, determine when there is the concurrence of the physical and mental elements, as well as exceptions which have been developed through cases. Main content. 3.1 The physical element. The physical element of an offense may manifest by way of a positive act, because intent alone, however wicked and condemnable, cannot amount to an offense. For example, if I slap a person in a manner not justified by law, I have committed the offense of criminal assault against that person, and that slap against him is the physical element. Also, if I move a bag to the slightest degree with the intention of permanently depriving the owner of the use of that bag, I have committed the offense of stealing against you, and the movement of your bag to the slightest degree from its original position is the physical element, or the actus reus of that offense. The physical element or the actus reus of an offense can manifest in words in respect of certain offenses such as defamation, sedition, taking of unlawful oath, and even conspiracy. These offenses are committed by words of mouth. The physical element is constituted by words uttered by the accused person. The physical element, also known as the guilty act, can also manifest by way of possession. It is immaterial that the accused has not begun to put that thing in his possession to any unlawful use. Section 148, subsection 3 of the Criminal Code provides for unlawful possession of counterfeit coin or of a means of making one. Mere possession of the counterfeit coin is enough to constitute the physical element of that offense. It does not matter whether you have put the money to use by way of using it to buy. For more on this, see sections 150, 154, subsection 2, 155, subsection 1, section 209, and section 213, etc. of the Criminal Code Act. Possession here may not be physical only, it can also be through the agency of another person, in which case it will be constructive possession. The physical element of an offense can also manifest by way of a passive state of affairs. If, for example, a club or an association in which you have been a member is now banned by government, you are ordinarily supposed to stop forthwith your membership of such a club or an association. But where you continue membership after the ban now becomes the physical element of that offense. Also, the physical element of an offense can manifest by way of an omission. Omission is failing or omitting to do what that law has commanded you to do, the failure of which will ground criminal liability. The Criminal Code has criminalized such omissions to include duties imposed on peace officers, police officers, to suppress riots, see section 199 of the Criminal Code, duties imposed on members of the ship's crew to obey order and duty, placed on a family head to supply necessaries for a child under 14 years of age. One underlying condition which must be present for omission to constitute the actus reus in criminal law is that such duties criminalized as omissions must be geared towards avoiding risk of serious harm to the person where a special relationship exists between the parties. The mental element or the guilty act can also manifest by way of consequence. In some offenses, such as murder and manslaughter, it is the consequence, for example death, which results from the conduct of the accused person that constitutes the actus reus of such offenses. Self-assessment exercise 1. What are the various manifestations of the physical element? The mental element. The introduction of mental element in crime may be attributable to ecclesiastics who regarded the conscience of men as prime importance. In their view, that which called for atonement was the evil intention or motive which prompted the harmful deed. The mental element